Here's a question for you. An elderly family member like your mother or father has lost mental capacity through illness or an accident and can no longer maintain control of their financial affairs. I'll call that person the donor. They never established a lasting power of attorney, so you can't look after their financial affairs or their health and welfare affairs. I want you to imagine being powerless to make any decision about their finances or care. How would you feel about that? To gain control of the donor's financial affairs, you may have to apply for something called deputyship with the Court of Protection. This process will impact upon you far more financially. It requires a full court application to the High Court, and this firm's fee for conducting that work would be at least £1,600 plus VAT and a court fee of £400. Not only this, but the Court of Protection will continue to have an involvement in overseeing the activity of the deputy. The court will also require the deputy to take out a guarantee, the premium for which can be significant. Every year the deputy will be required to complete a detailed return accounting for all their activities and also every penny that they have received and spent on behalf of the patient. The court charge for their involvement in this process year by year, and the fee they charge is based on the value of the assets of the donor, so this yearly charge could impact upon you considerably and cause you and your family member a lot of aggravation and possibly distress. By ensuring that a lasting power of attorney is in place, the need for deputyship is greatly reduced. When a loved one establishes a lasting power of attorney, they are ensuring that their family is given the legal power to manage their financial and medical affairs, and that is real security for both parties. Anyone over the age of 50 should really consider preparing a lasting power of attorney and register it as soon as possible. There are two types of lasting power of attorney, and one may be more appropriate to you than the other, or you may feel the need for both. It is easy to put this off and leave it for another day. Remember though, you can only make a lasting power of attorney if you have mental capacity. And no one knows what's lurking around the corner in life. As I've said, there are two types of lasting power of attorney. The first is the property and financial affairs lasting power of attorney, which replaced the enduring power of attorney in October 2007. If an enduring power of attorney is already in place, a lasting power of attorney may not be necessary. A power of attorney property and affairs enables the attorney to run, for example, the donor's bank account and look after all their personal business matters. Registering a property and financial affairs lasting power of attorney means the attorneys can act for the person granting the power even if they retain mental capacity. This is useful for people who simply don't wish to be bothered by looking after their affairs anymore. However, in most cases, the attorney will only use their power once the person has lost mental capacity. The second type is a health and welfare lasting power of attorney. This document gives power to the attorneys to make clinical decisions for the donor when they are unable to do so, and also relates to, for example, where the donor lives and associated issues. Under this form of lasting power of attorney, it is not possible to exercise any powers until the donor has lost their mental capacity. If the donor of the power is capable of making a decision, then the attorney should do everything in their power to give the attorney the opportunity to make that decision. Therefore, attorneys should always consult the donor about a decision to see whether they are able to make that decision for themselves. Once the donor has decided to make a lasting power of attorney, they then need to decide how they wish to prepare the documents. This is something we at You at Price can provide for a fee. Our fee for preparing a lasting power of attorney, property and affairs, or health and welfare is £400 for each document plus VAT. Currently the registration fee is £110, and we strongly recommend that this document is registered immediately after it has been completed. These fees may vary in the future. If an individual or a couple make two lasting powers of attorney together, we discount that figure to £600 plus VAT. However, the registration fees will remain at £110 for each document. Or, if a couple were to choose to make 2 lasting powers of attorney each, one for property and financial affairs and the other for personal health and welfare, then we would charge £1,200 plus VAT, plus 4 lots of £110 for the registration fees. These fees may vary. Or, if you prefer, you can prepare a lasting power of attorney yourself by going to the government website gov.uk. There you can find software which will help you prepare the lasting power of attorney you desire for no fee. After this, you will need to register the document to complete the process.
Once the individual has decided to embark on preparing a lasting power of attorney and has approached us at Ewart Price, we will arrange a meeting so we can go through the document thoroughly as a group and explain all aspects of the document clearly. During a meeting like this, we would need to discuss who you are planning to appoint as attorneys, along with their full name, full address, date of birth, and we will discuss if you wish to have replacement attorneys. The registration process includes sending notice to a third party to ensure that everything is above board and to give that third party the opportunity to challenge the process of registration should they consider that necessary. We understand that some people may find it difficult to get into the office for various reasons, so we are more than happy to visit you at home to go through the relevant paperwork. As solicitors, we can also provide certification, which is a requirement of the process. There is a strict order in which the form must be completed. Part A of the form must be signed first by the donor. Part B, which is the certification process, must be signed directly after Part A. And Part C, which is where the appointed attorney or attorneys accepts the role and finalises the documentation. If you wish to discuss lasting powers of attorney, then we're more than happy to meet with you to talk things through. We do, however, reserve the right to charge for meetings like this. But by and large, the discussion is likely to proceed to the preparation of the documents, and we wouldn't add an additional charge for any prior advice.
Once a lasting power of attorney has been registered, the attorneys can use those powers for the benefit of the donor or donors. It is possible that someone may wish to challenge the registration of the lasting power of attorney. This may be due to worries that the donor was placed under duress or pressure by the attorneys. If Ewart Price are instructed, the likelihood of a challenge emerging is hugely diminished because we use our professional independence and expertise to ensure that any potential difficulties are sorted out quickly and smoothly. The lasting powers of attorney deals with legal affairs up to the moment of your death. After that, your will determines what happens to your estate. We here at Ewart Price want you and your family to have peace of mind. Imagine how bad things could end up without setting up lasting powers of attorney. We can help you to make sure that doesn't happen, but you have to meet us halfway. Make the right decision today to protect the future of your family tomorrow.